afternoon, ladies and gentlemen. We're about to call the session to order. We implore all our panelists and guests to please come into the hall so we can start the session. Please, please, please. We invite everyone to come into the hall so we can start the session 2 in earnest. Thank you very much. Good afternoon, my lords, learned silks here present, ladies and gentlemen, captains of industry. It's a pleasure to welcome you to session 2 of day 3 of the annual Criminal Law Review Conference 2024. The topic that the discussants would take today is substantive evidence, common pitfalls in criminal trials, diligence, and the role of counsel. It's my pleasure to introduce the chairman, Are Olumoyiwa Akimbo, Senior Advocate of Nigeria. And the lead presenter, Mr. Adedayo Adedeji, Senior Advocate of Nigeria. Please let's give him a round of applause. We also want to recognize the panelists. Honorable Justice Celestine Odoje of the High Court of Federal Capital Territory. We want to recognize Mr. Osage Isirame. Please give him a round of applause, one of our panelists. Mr. DK Odena is on his way. He's sending representatives, and Mr. Anone Osman is on his way. With the leave of
Mr. Oni, if you can hear me, please for interrupting. Can you hear me?
Yes, we can hear you.
Yes, yeah, the audio is not the audio output here.
Oh, I see.
We can't hear you clearly.
I see.
Please,
technical, could you please take note of that? Thank you for that observation.
Yes, thank you.
Before I yield the microphone to the chairman, I would like to just go through the profile of the chairman and the lead presenter and other panelists very briefly. Are Olumuyiwa Akimboro, Senior Advocate of Nigeria, is a distinguished Senior Advocate of Nigeria, a life bencher who has made extensive contributions to the Nigerian legal field. He has played significant roles within the Nigerian legal community. He served as the General Secretary of the Nigerian Bar Association and held other significant MBA roles, including as a former chairman and secretary of the Abuja branch of the Nigerian Bar Association. His professional accomplishments and dedication earned him the designation of life bencher, a prestigious recognition in the Nigerian legal field. Are Olumuyiwa Akimboro, Senior Advocate of Nigeria, is known for his advocacy, gender equality, professional integrity within the legal profession. His support for the Nigerian Bar Association, Women's Forum underscores his commitment to uplifting women in law and advancing equity within the profession. Beyond his legal accomplishments, Are Akimboro is known for his philanthropy, especially in supporting underprivileged, and has been honored as Are Bamofin of Kuta Kingdom. We welcome you and we recognize you. Thank you very much, sir. We also have Mr. Adedayo Adedeji, Senior Advocate of Nigeria, who is the lead presenter. He began his legal career in the firm of DAUDU & Co., where he advanced to the position of head of chambers in the firm's Abuja office. Mr. Adedeji is known for his extensive expertise in various legal domains, including general litigation, appellate practice, constitutional and statutory interpretation, criminal law, and pre- and post-election dispute resolution, where he has represented clients in high-stakes cases across different jurisdictions. In recognition of his distinguished contribution to the legal profession, Mr. Adedeji was conferred with the prestigious title of Senior Advocate of Nigeria in the year 2023 by the Legal Practitioners Privileges Committee. His achievements and progression underscores his commitment to the advancement of justice and inspire the upcoming generation of Nigerian lawyers, laying a foundation for a career marked by exceptional client representation and legal proficiency. Please give him a round of applause. Mr. Osage Isirame, one of our panelists, is a dedicated and passionate lawyer serving as the head of chambers of the DAUDU & Co. Kaduna branch, with a career spanning over years that has become a driving force within the firm. He's recognized for his deep commitment to justice, keen legal insight, and strong leadership skills. He's focused on litigation, arbitration, and insolvency law. He has been active in various international legal trainings and is well-versed in legal practice across multiple jurisdictions. He has a certificate of attendance from the Hague Academy of International Law, Peace Palace, The Hague, Netherlands. He's a membership of Nigerian Bar Association, the Commonwealth Lawyers Association, Business Recovery and Insolvency Practitioners of Nigeria, RIPAN. Please let's give him a round of applause. With the leave of the chairman, I'll yield the mic so that we can proceed. Thank you.
Thank you very much, the MC. I want to welcome my lords here present, all our conferees. I want to welcome all of us to this afternoon session. The topic for this afternoon is common pitfall in criminal trial, diligence, and the role of defense counsel. I will not go forward without also welcoming all our participants online, and particularly those that are participating from the glass house in LOKOJA. You are welcome to this afternoon session. Please, I want to beg and seek the leave of my Lord, Honorable Justice Odo, to please come to the front so that there'll be synergy between us and our panelists. Please come forward, my Lord. And also, my brother, Osage Isaraman, please come forward so that we know it will be easy to communicate. And my Lord, there's a seat. I don't know why my Lord. Yeah, I don't know why my Lord is avoiding me. Is that something? Is this something personal? Yeah. Thank you for the privilege, my Lord. To sit next to a judge of the High Court is not the main thing. I'm privileged. Thank you, my Lord. Yes, my Lord. Now, to start, we need to send the grand rule so that it will be a swift session, and which will be very intellectually nourishing for our members. And with the leave of my Lord, it should be the one to have made the rules, but unfortunately, they made me chairman today, and that's fall within my own limits. So the lead speaker, I will plead with the lead speaker to let us, within 20 minutes, impact as much as we can impact. That's it. Okay. I've been corrected by a judgment of court, which I've cited Supreme Court ruling and precedents that it's 30 minutes. So 30 minutes for the lead speaker, then the discussants, we have 15 minutes each. So without wasting any more time, I want to call on my brother Adedayo GSN to present his paper.
My lords here present, learned senior advocates, the chairman of session, my colleagues, please permit me to stand on the already existing or established protocol. My task, or my duty this afternoon, I think is quite simple and straightforward, taking into consideration the topic under discourse. The topic is common pitfalls in criminal trials, diligence, and the role of defense counsel, being a defense counsel. From this topic, it is apparent that it is a topic that is steeped in its practicality rather than theorems. In the criminal justice system, the role of a defense counsel cannot be overemphasized. Their role is crucial in ensuring that the defendant receives a fair trial. Indeed, one of the key qualities a defense counsel must possess is diligence, particularly in carefully reviewing all available evidence and identifying any inconsistencies or gaps in the prosecution's case. In this regard, ladies and gentlemen, I have identified some common pitfalls which I consider are recurring issues in criminal trials from the perspective of a defense counsel. This paper is divided into sub-paragraphs, each sub-paragraph depicting various pitfalls. Without further ado, I will plunge straight into the topic. And I will start with a subtopic I have christened extrajudicial statement in criminal trials. For those of us who are familiar with criminal trials, will know that this is something that occurs, or this is something you always come across, particularly if you're a defense counsel. Now, a common pitfall in criminal trials regarding substantive evidence is the use of extrajudicial statements obtained during investigations. The challenge often revolves around the correct procedure for utilizing extrajudicial statements to question a witness credibility. This aspect of the trial is often misunderstood, not only by defense attorneys, but also by the prosecution and in some instances by the trial court. The Black's Law Dictionary defines an extrajudicial statement as a statement written or obtained outside the court. And our courts too have been consistent on the definition of what an extrajudicial statement is, which is defined as a confessional statement, and indeed what was done outside the court. Generally, extrajudicial statements are not considered legal evidence and are therefore inadmissible in court both for the prosecution and the defense. This principle was established as far back as 1989 and even before then by the Supreme Court in the case of Aclrc versus the state, where my Lord Utako-Abuja of blessed memory held that extrajudicial statements of the prosecution witnesses, if not tendered as exhibits, cannot qualify as legal evidence in either the appellate or the trial court. The only proper use of extrajudicial statements by witnesses is for cross-examination to discredit their testimony. Now, since the case of Aclrc up to date, the court have consistently held this position, and by the doctrine of stare decisis, the trial court have also been bound by this age-old principle of law. In following this principle, it has been held that any legally inadmissible evidence remains inadmissible and cannot form the basis of the court findings, even with the consent of the parties or their counsel. In applying this principle, the Court of Appeal set aside the appellant's conviction and life sentence, holding that the defense's failure to object to the admissibility of the extrajudicial statement by P.O.W. 2 and P.O.W. 3 when tendered the evidence by the prosecution did not confer any legality on the statement. In the words of Oyewole JCA, counsel or even parties cannot by consent taint a trial with illegality. Now, in the case of Dankara, this is the case of Dankara versus FRN, which is a 2024 decision of the Court of Appeal. And the Court of Appeal in this particular case followed the long line of decisions of the Supreme Court to the effect as to what an extrajudicial statement can be used for. In this particular case, the Court of Appeal set aside the conviction of the appellant to life imprisonment on the ground that the extrajudicial statement that was tendered in evidence was wrongly admitted by the trial court. What had happened was that in the course of testifying, the investigating officer, that's the IPO, tendered the extrajudicial statement in evidence without an objection for the defense. And when he got to the Court of Appeal, coincidentally, I argued the matter at the Court of Appeal. When he got to the Court of Appeal, part of the argument we raised was that that extrajudicial statement that was tendered and admitted by the court or by the trial court was wrongly admitted in evidence. And the Court of Appeal agreed with our submission that no, that even though the prosecution did not, even though the defense did not object to the admissibility of that extrajudicial statement when it was sought to be tendered by the prosecution through the IPO, that does not in itself make it admissible in evidence. Now, why tender an extrajudicial statement of a witness during criminal trial? I think the question lies in Section 232 of the Evidence Act, which says that a witness may be cross-examined as to previous statements made by him in writing relative to the subject matter of the trial without such writing being shown to him. But if it is intended to contradict such witness by the writing, his attention must, before such contradictory proof can be given, be called to those parts of the writing which are to be used for the purpose of so contradicting him. Now, what are the key points from this Section 232? To me, They are one, under cross-examination, a witness can be cross-examined as to his previous statement in writing. Two, the previous written statement must be related to the current charge. And three, a previous statement can only be used to contradict a witness after the attention of the witness is drawn to the contradictory parts of his previous statement. And four, the trial court reserves the power ultimately upon production or to determine whether or not a contradiction has been established. Now, before you can rely on an extrajudicial statement, going by the provisions of Section 232, there's a need for a proper foundation to be laid. And I think this is where the problem usually occurs, particularly from the perspective of a defense counsel. From experience, I have noticed, or yes, you have noticed that in most situations, defense counsel do not really understand how to make use of an extrajudicial statement, particularly during cross-examination of a witness. Now, part of the pitfalls that I have noted, or part of the errors that I noted, is that some defense counsel will seek to tender the extrajudicial statement in evidence before confronting the witness with the inconsistency, or relying solely on the statement and the proof of evidence without applying for the original from the prosecution. This approach, we respect, clearly violates Section 232 of the Evidence Act and plethora of authorities on the point. From the consistent decisions of the Court of Appeal and the Supreme Court, and I refer us to a very recent decision of the Supreme Court, which is the case of Mafemi versus COP, where the Supreme Court clearly stated what the procedure is. And of course, this decision of the Supreme Court is in line with the consistent positions the Supreme Court and the Court of Appeal has taken on how to tender extrajudicial statements at trial. One is to request the original copy of the extrajudicial statement from the prosecution. That's the first step. Two, confront the witness with the inconsistent portion of their testimony in court. And three, allow the witness an opportunity to explain or reconcile the inconsistency and then apply to tender the extrajudicial statement in evidence. Another pitfall that I have highlighted in my paper is cross-examination. Cross-examination of witnesses on all elements of an offense. Criminal trials are often won or lost at the stage of investigation. Without a thorough investigation that secures the evidence necessary to establish the element of an offense, the prosecution may struggle during trial. Similarly, for a defendant to present a solid defense, it is essential for the defense to understand the charges and examine all available evidence. This involves identifying the elements of the offense and comparing them with the evidence provided. Without a firm grasp of these elements, a defense will likely falter even if the prosecution's investigation was inadequate. Now, the relevant section on that reference is Section 233, but I won't bother us with that. I'll just go straight to judicial interpretations with that, in respect of the section. With this, in respect of Section 233, we have the case of Follett versus the state, where the Supreme Court held that it is plainly unsatisfactory, if not suicidal, bad practice for counsel to neglect to cross-examine a witness after his evidence in chief in order to contradict him or impeach his credibility while being cross-examined, but instead attempted to do so only by calling other witnesses or witnesses thereafter. According to PA GKGSC, the proper course is to challenge the witness while he's in the witness box, or at any rate to make it plain to him at that stage that his evidence is not being accepted. If the adversary fails to cross-examine a witness on the material fact, it is assumed that they accept the facts as true. A common pitfall for defense counsel is failing to focus cross-examination on the element of an offense and generally on the relevant facts as it relates to the charge. Cross-examination questions should specifically address the more specifically address whether the prosecution has proven these elements from the evidence presented. As a defense counsel, the primary duty is to identify the elements of the offense and juxtapose same with the available evidence before the court, and ensure that nothing is left unturned in crossing or crushing the evidence of the prosecution. Hiding under the aphorism that sky is the limit in cross-examination to ask irrelevant questions that do not challenge the available incriminating evidence is not only a disservice to the defendant, but to the cause of justice. In the case of Ishiono versus Julius Berger, my Lord Justice Nick Itobi, of blessed memory, expressed that the notion that there are no limits in cross-examination is not sound legal practice. The key principle in all types of examination, including cross-examination, should be relevance, as relevance is a core principle of the law of evidence. Now, following the principle established in the case of Ofolet versus the state, the Supreme Court in the recent case of Aputa versus the state, which is also a 2024 decision of the Supreme Court, reiterated that when a prosecution witness testifies on a critical point that the opposing party seeks to challenge, the opposing party must present contradictory evidence during cross-examination to indicate non-acceptance of the testimony. For example, the appropriate time to confront a witness considered to be tainted. The appropriate time to confront a witness considered tainted is under cross-examination and not in the final written address or an appeal. In Maminu versus the state, the appellant raised the issue on appeal at the Supreme Court for the first time that certain witnesses were tainted as they were related to the deceased. The Supreme Court dismissed it as an argument, stating that it was raised too late and should have been addressed during the trial with the witness confronted on this issue during cross-examination. The Supreme Court has consistently reiterated that the importance of cross-examination in criminal trials, emphasizing the crucial role it plays in challenging the prosecution's case and establishing the truth. Rather than conducting a thorough cross-examination on all elements of the offense, it is common for defense counsel to rely on their written address to demonstrate that the elements of the offense have been proven. The court has consistently emphasized that no matter how well written, the counsel's final written address cannot substitute evidence. The court's unwavering position underscores the critical importance of cross-examination in criminal trials and highlights the detrimental impacts of failing to cross-examine a witness on vital elements of an offense. Another pitfall relates to the objections to confessional statements. We had talked about confessional statements earlier this morning as to the issue, as to the admissibility of same, whether it should comply with the provisions of the administration of the Criminal Justice Act before it can be admissible in evidence. Now, my own perspective is different in the context of this paper. I'm not talking about the issue of whether it is admissible or not, but rather I'm talking about what stage or what is your role or what is our role as defense counsel when it comes to confessional statements. And this is my thought on it. Another key aspect of criminal trials is objecting to the admissibility of confessional or extrajudicial statements. It is common for the defense to object. Often arguing that the confessional statements were not made voluntarily. While it is within the right of a defendant through their counsel to raise such objections, this stage of criminal trials is often misunderstood and misused by the defense. And when I say misunderstood and misused by the defense, in our previous session, a distinction was drawn between objection to the admissibility of a confessional statement on the ground that it is involuntarily made, and objections on the ground that the retraction of the statement, in other words, the witness or the suspect is disowning authorship of the said statement. Now, irrespective of whether it is involuntary or whether it is retracted, the common trend or the common objection is that it is involuntary, right? So that is where the role of a defense lawyer comes in. to liars, or be sure as to what is the line of your objection. Is it on the is your objection premised on the ground that it was involuntarily made, taking into the circumstances in which the confessional statement was obtained? Or is it that the suspect or your client is saying, I did not make the statement? Irrespective of whether it is involuntary or whether it is a retraction, the law, as settled by plethora of decisions, is that the appropriate time to raise an objection to such a statement is at the time the prosecution intends or seeks to tender that statement in evidence. Now, can a confessional statement be rejected or deemed inadmissible in evidence based on the defendant's denial of authorship of the statement? There's a distinction between objections to the admissibility of confessional statement due to involuntariness and the retraction of a confessional statement. The Supreme Court has consistently held that if a confessional statement is challenged based on the defendant denying making the statement should be admitted since its admissibility is not affected. However, if a confessional statement is objected on the grounds of involuntariness, such as being forced or induced to make it, then the trial within trial must be conducted. In this scenario, the burden of proof, of course, lies on the prosecution to prove beyond reasonable doubt. As previously noted, this aspect of criminal trial is often misunderstood. Whether the objection pertains to involuntariness or denial of the statement, the common ground for objections often revolve around the voluntariness of the statement, leading to a trial within trial to determine its voluntariness. To avoid these common mistakes, defense counsel should clarify the nature of their objection with the defendant before the statement is tendered. Is the objection based on involuntariness or a complete denial of the statement? Regardless of the nature of the confessional statement, the consistent stance of the Supreme Court is that any objection to the admissibility of a confessional statement should be raised when the statement is being tendered in evidence. I've referred to some authorities of the Supreme Court on it. I talked about more recently is the case of Habibu versus the state, where the Supreme Court reaffirmed that the appropriate time to object is when the statement is being tendered as evidence. In other words, a statement will not be permitted, a defendant will not be permitted to challenge the admissibility of a confessional statement even at the trial court after same has been tendered in evidence. The failure of the defendant or their counsel to raise an objection to the admissibility of a confessional statement does not prevent the court from considering the content of the statement and assessing its legal implication alongside other corroborative evidence before reaching a decision, particularly in cases involving capital punishment. This is the position of the Supreme Court in the case of Abu versus the state, delivered also and reported in 2024. Another pitfall has to do with right to adequate time and facilities in criminal trials, which is the common provision I think everyone is familiar with, even with non-lawyers, which is Section 36 of the 1999 Constitution. Now, imagine being accused of a crime and having no access to the evidence against you. Of course, your freedom is at stake, yet you are forced to fight without the necessary tool to defend yourself. This scenario underscores the importance of the right to adequate time and resources for every accused person to prepare their defense. The right to adequate time and facilities for the defense in criminal trials is a fundamental principle provided in the Constitution, which is Section 36 sub 6b of the 1999 Constitution. In interpreting this constitutional provision, the court has been consistent in holding that any person charged, whether summarily or by information, is entitled to detailed knowledge of the offense, including the proof of evidence by the police to facilitate their defense. Now, the fundamental point in respect of this pitfall, in my view, are three dimensions. One, what is the role of a defense counsel in ensuring that his client has adequate facilities to defend the charge? Second, at what point should objections be raised to inadequate facilities for the defense? And third, what is the effect of the prosecution denying the defendant adequate facilities to defend the charge against him? One, on the role of a defense counsel in ensuring that his client has adequate facilities to defend the charge, it is to ensure that the proof of evidence provided by the prosecution contains all relevant documents obtained during investigation to assist in defending the charge. In practical terms, the prosecution in most cases will only provide documents that will assist the prosecution in proving the charge beyond reasonable doubt, and not necessarily documents that will assist the defendant. At every point, the defense must be diligent and observant in ensuring that whatever evidence is being tendered by the prosecution, particularly forms part of the evidence, forms part of the proof of evidence served on the defense. Also, in the same vein, it is within the constitutional right of the defendant to demand from the prosecution existing documents not included in the proof of evidence if such documents will be relevant in defending the charge. Experience have shown that in some criminal trials, when proof of evidence are being served on the defendant, that some of the documents that were obtained during the investigation do not form part of the proof of evidence. And in some instances, some of those documents that are excluded or that are not included in the proof of evidence but were obtained during the course of the investigation are documents that indeed exonerate or are going to be useful for the defendant's case. In that situation, it is the role of the defense counsel to ensure that he identifies that such a document is not in the proof of evidence. In other words, what I'm saying in summary is that we are not bound by the proof of evidence that the prosecution gives us. If deep within us, based on the available defense, we think that there are some documents that are excluded, it is important that we raise an objection immediately in respect of that. And I refer also to the case of Okemini versus COP, where my Lord Ogunwumiju, in line with previous decisions of the Supreme Court, highlighted the importance of Section 36B as it relates to facilities to defend, prepare, and defend, for the case, and the fact that the prosecution cannot be allowed to have sole access. She said the prosecution cannot be allowed to have sole access. I think it is important for judges at all levels, particularly trial judges, to be aware of their duty to the defendant. The criminal trial is not a prosecution. It is a prosecution and not a persecution. On the second question, as to the appropriate stage to raise an objection. Now, such an objection is best raised at the beginning of trial, as failure to raise these objections early could hinder the defense's ability to counter the prosecution's case. And I refer us to a locus classicus on the point, which is the case of Shema versus FRN, where the Supreme Court held that an application for facilities, such as the statement of accused persons and all other prosecution witnesses, investigation reports, etc., were premature because at the time the application was made, the appellant had not taken their plea to the charge. From the decision of the Supreme Court on this point, it is safe to conclude that such an application can only be made after a defendant has entered his plea, but before the actual trial commences. The defendant or counsel representing him should be availed of all the facilities that will assist in the preparation of his defense. On the effect of the prosecution denying the defendant adequate facilities to defend the charge against him, I refer us to the case of Nweke versus the state, where the Supreme Court held that the right to facilities for the defense to prepare his defense is not self-executory. The defendant has to make the request directly to the trial court, either orally or in writing, for the prosecution to oblige the defense with the facilities that will enable the defendant to prepare his defense. By the decision of the Supreme Court, all requests for facilities must be made directly to the court and not to the prosecution, and as such must be granted. The consequences of denying the accused access to adequate facilities upon request can lead to a breach of fair hearing. The position taken by the Supreme Court in plethora of decisions is not to quash the charge upon such denial, but rather direct that such facilities be made available to the defendant and the case remitted back to the trial court for continuation of trial. On this point, I'll refer us back to the case of Okemini versus COP, which is a case of the Supreme Court, also a 2024 decision of the Supreme Court, which I find interesting. And what had happened in the case was that the appellant The matter actually started all the way from the magistrate courts up to the Supreme Court. And what happened here was that at the magistrate court, the appellant was charged for unlawful possession of firearms, in which he pleaded guilty. Upon his arraignment, he applied to the courts to direct the prosecution to serve him with a proof of evidence, but the application was refused by the magistrate. He was dissatisfied, and he appealed to the High Court. The High Court also dismissed it, and further appealed to the Court of Appeal. The Court of Appeal also dismissed it, affirming the decision of the Court of Appeal, saying that his trial was a summary trial, and as such, he was not entitled to a proof of evidence. The appellant then further appealed to the Supreme Court, and the main issue for consideration by the Supreme Court was whether the constitutional provision of Section 36(6)(b) as to the right of a defendant to adequate facilities to prepare his defense is applicable to summary trials. For those of us who practice in magistrate court, I think this is an authority that's going to be very useful to us. In allowing the appeal, the Supreme Court held that the need for the strict categorization of the mode of trial into summary trial or on information cannot outweigh the fundamental requirement of fair hearing. Irrespective of whether it is a summary trial or a trial by information, every defendant is entitled to facilities to prepare his defense. The Supreme Court held that the need for an elaborate procedure to be endured by the defendant before he can secure the materials gathered against him by the prosecution is warranted and adds a burden on the defendant seeking to prove his innocence. It is not justifiable, particularly in a summary trial. The Supreme Court, in allowing the appeal, held that the defendant was entitled to all the statements and other materials in the custody of the prosecution in order to adequately defend himself, and consequently remitted the matter back to the Chief Judge of Ebonyi State. It was a matter that happened in Ebonyi State for reassignment to another Chief Magistrate for speedy trial of the appellant. Now, I have a reservation with the judgment of the Supreme Court. Well, this is from the perspective of the defense counsel. You permit me to say that. Is that as sound as the judgment of the Supreme Court appears, one would have thought that the Supreme Court would have quashed the charge, having found that the prosecution breached the appellant's human right to fair hearing for failure to provide him with facilities to defend his charge. Quashing would have served the cost of justice, given the numbers of appeal on this matter. It is pertinent to note that this right, though constitutional, is not absolute. The court recognizes that limitation to this right may occur involving national security or witness protection, or to keep secret the methods used by the police in the investigation of crime. So this decision basically is to the effect that irrespective of whether it is a trial, is a summary trial, or it is a trial that is by information, that an accused person or the defendant is entitled to facilities to prepare for his defense. In as much as those facilities are in the custody of the prosecution, it is within his right to apply to the court for those documents, and if it doesn't fall under any national exceptions of national security, the prosecution is obliged or is mandated in the circumstance to make such documents available. Another pitfall, again, which I noted, is in respect of the area of amendments of charges. And the issue I've raised here is whether amendment is granted as a matter of course. Is amendment granted as a matter of course because Section 216 of the Administration of Criminal Justice Act provides for same? Can amendments be granted after evidence has been led in criminal trials, particularly when the prosecution has led evidence and the matter has been adjourned for the defendant to open his case, or maybe when the prosecution has closed his case and the defense has opted for a no-case submission? Can an amendment be granted in that circumstance? Yes. The answer is in the affirmative, going by the provisions of Section 216 of the Administration of Criminal Justice Act. But the trend is that such amendments must be justifiable, When deciding whether to oppose such an application, the defense should remain vigilant to ensure that the amendment sought by the prosecution does not in any way prejudice their case. Experience has shown that once the prosecution closes their case, they come up with an application to amend, relying on Section 216. And in some cases, what we see is that such an amendment that are meant to overreach the defense, particularly when their case has been badly damaged under the heat of cross-examination. So now, what is our role as defense counsels in this respect? Our role as defense counsels in this respect is to ensure that we juxtapose the amendment or the proposed amendment with the evidence led and see or ensure that what is being brought is not an amendment that seeks, to repair the case of the prosecution that has been badly damaged. Amendments aimed at creating an entirely new case for the prosecution or addressing flaws exposed by the defense during cross-examination should be vehemently opposed. The prosecution should not be permitted to misuse Section 216 of HARDSHIP to fundamentally change their case in a way that prejudices the defense. This consideration, we respect, does not only apply to trial courts, which often also applies to trial courts, because the trend is that once those applications, and I'm saying this from experience, is that once such applications are brought, the courts, in most situations, will grant such an amendment, relying on Section 216 of the HARDSHIP. And my view is that the permission or the right to amendment of the prosecution to amend the charge anytime before judgment under Section 216 of HARDSHIP is not as a matter of course. It is not as a matter of course. That is my provision on Section. And finally, another pitfall I raised is on the constitutional right of an accused person to an interpreter. An accused person has a constitutional right to an interpreter if you do not understand the language used at the time of arrest and trial. This right is guaranteed by Section 36(6)(a) and (e) of the 1999 Constitution. This provision establishes that an interpreter is mandatory if the accused does not understand the language used in court. If it is established that the defendant does not understand the court's language, the court must provide an interpreter throughout the trial proceedings. However, this constitutional right is rarely invoked by defense counsel on behalf of clients who do not understand the language of the court. There is often an assumption that the defendant understands the court's language if they are represented by counsel who does. In other words, if the counsel understands English, which is the language of the court, there's always an assumption that the defendant also understands the language of the court. But in some cases, it is not like that. So it is left for us as defense counsel to always know that we have this right embedded in the Constitution. Regardless of a defense counsel's understanding of English, it is their duty to request an interpreter from the court if the defendant does not understand the language. Failure to do so implies that the client understands English language. In State versus Salihu Mohammed Goto and others, the Supreme Court held that if neither the defense counsel nor the accused objects to irregularities like the absence of an interpreter, the right is forfeited and cannot be claimed later at the Court of Appeal or the Supreme Court. Similar position was held in the case of Aputa versus the state, where the Supreme Court held that if the appellants could not understand the language or comprehend the charges, they had the opportunity to seek legal advice or provide instructions for an interpreter. We've had situations whereby if not that an interpreter was provided for the defendant, the prosecution would have gone ahead to tender some documents which ordinarily should not have been tendered, if not for the fact that the defendant brought it to the attention of his counsel, the circumstances surrounding how those evidence or how those documents were obtained from him. I go to my conclusion. To avoid some of the highlighted common pitfalls, of course, which are not exhaustive, but some of which I consider a recurring decimal in criminal trials, in criminal no doubt requires diligence. Defense lawyers must always be alert and proactive in tackling some of the challenges that arise during trial. Criminal trial is likened to a balloon. It's like a balloon. And all you as a defense attorney is working towards is simply just to put in a tiny dot to burst the balloon, no matter how little, to create the necessary doubt in the mind of the judex. According to Benjamin Franklin, if you fail to plan, you plan to fail. Without a clear strategy, it will be difficult to surmount some of these highlighted pitfalls. Ladies and gentlemen, thank you all for listening. I look forward to your thoughts on this topical issue.
Please, another round of applause for the senior advocate. When they say that in the house, when they are elders, the likelihood of making mistakes are minimal. I want to appreciate my Lord for also advising that 20 minutes will not be adequate. At the end of the day, we spend 40 minutes, and it's a good 40 minutes when spent. A round of applause for my Lord for the guidance. The learned senior advocate took us around this paper that centers not only on the issue or the main central issue in criminal prosecution, which is fair trial. And in order to attain this, he also told us the place of diligence. When he went forward to identify the pitfalls that he has identified from experience and from research, which also include the extrajudicial statements, written or not written, within or outside the court, and the use of those statements in cross-examining or contradicting the witness. He also brought forward, when do we employ this as a defense counsel? On the second, he raised 3 or 4 issues, and the second one, light to adequate time and facilities. Those are constitutional rights of an accused person, and how and when to demand for those rights to be abided with. The third one is also the amendment of charges. So that in the case where we should be vigilant to make sure that charges are not being amended to fill the holes that the defense has already dug in the case of the prosecution. And also to write to an interpreter. All these things are things that as diligent defense counsel we need to open our eyes to. They are not to be employed to as a tactic only to make sure that every accused person that you are defending, you use every technical issues to get them out of it. Yes, they are entitled to a good defense counsel, but at the back of our head, and that was the first thing we said, we must target for the fair trial of the accused person. So I will also want to now call on my Lord, Honorary Justice Odu, for his contribution, and I don't know whether I should just put him on the. My Lord suggested 15 minutes. Yes, but if 15 minutes or not, if it's as sweet as what we have just eaten, I don't know whether it will become my 15 minutes. But please, let's make it. Yeah.
Good afternoon, Chairman. Good afternoon, my lords. Please permit me to lay on existing protocols. Our paper today, as the lead presenter said, is a very simple one. Though it is still a big one, because when you talk about role of the first counsel in criminal trial, it starts from the beginning to the end. So it's very wide indeed. And I commend the lead presenter because he did a very good job in the area. But I have to, because of the duty of the Defense Council, because it's so wide, I have to touch other areas that maybe that will be very, very necessary. I will start with the role of Defense Council in criminal trials. And I will start from the lower court first, because I know some magistrates are here, and most of the lawyers here also appear in magistrate courts. And also permit me, when I will be going on, I will refer to two statutes, mainly ACJ and CPC. That's Criminal Procedure Code. You know, each time we talk about Criminal Procedure Code, some people will say, it has been repealed by ACJ. I said it last time, during this session last time, that it did not, and it's very clear, because section 493 that repealed some acts that did not touch Criminal Procedure Code Act 491, applicable to the FCT. It is that law that recognizes even the magistrate court, gave magistrates power to try offenses under the penal code, and also gives the power all the category of magistrates to try the different offenses, and also recognize the existence of magistrates in FCT in such a way that it has been repealed. There would have been no existence of magistrate court in FCT, because in FCT there's no statute creating magistrate court other than CPC 491. So when a case comes before a magistrate court, most of the time the magistrate will first of all go or consult the CPC Appendix A to know whether he has power to try that offense. So because of that, I have to say that CPC is still an extant law in FCT. It's still applicable, and will make use of it while the trial is going on. So the area where the role of the first counsel needed in trial, particularly in the lower courts, as I said, is the issue of criminal complaints. At times we do not advance our minds to this, though legally applicable in the lower courts. But this criminal complaint is such that it has been abused a lot, and there has been a problem of defense counsel and even the courts with respect to this issue of direct criminal complaint. Direct criminal complaint is such that you can just wake up and write, use the biro and the paper, say issue criminal process or someone against anybody, even your perceived enemy. And in this case, the court will issue criminal process and start trying the person. But when it comes to court, most of the time, I remember when I was a director of magistrates, it was a very serious issue. The defense counsel always quarrel with the procedure the court adopts. And I said I will use this opportunity also to just talk briefly on the procedure and also what is expected from the defense counsel. So in direct criminal complaints, the law provides that it can be brought orally or in writing. If it's brought orally, the registrar can take the complaint or the magistrate and also serve the issue summons with respect to that, or the defense counsel can file the complaint direct. So, and when it's filed, it's the duty of the court to know whether or not there's any offense disclosed or whether the defendant has a link with the commission of the offense. If he is satisfied, he issues summons directly for the defendant to appear and take plea based on that complaint. But if he is not sure, he's in doubt whether or not there's a prima facie case, he will now send it to police to investigate. And after the investigation, police to bring a report of the investigation, they enable the court make up its mind on whether or not it will issue someone against the defendant. And most of the time, when this complaint is given to the police to investigate and bring report within so time, what police does most of the time is to convert it to FIR or a charge and bring to the court. A good defense counsel should not allow that, because a direct criminal complaint is another method of institute proceedings in the magistrate court, so as that of first information report and a charge. So one cannot extinguish the other. And that report, that FIR being brought, charged by the police, cannot terminate the pending complaint before the court. In this case, when such is brought, it is the duty of the dutiful counsel, defense counsel, to raise an objection that it should not be allowed, and it should not be allowed at all. Then, the magistrate, if not satisfied that there's a prima facie case or that there is no need of proceeding, he can refuse to entertain it or invite the defense counsel. That he invites the defendant to court. So in this case, that should be the end of the case, because most of the complaints that comes before the court are civil in nature. Most of them landlord and tenants. And this case is not compulsory that the defendant should be invited. And it's the duty of the court to take that decision. Most of the time when it is filed, the complainant or his lawyer will always tell the court, please take it to police, or don't take it to police. It's not the duty of the counsel to do so. It's the duty of the lawyer to do so. Then, if we come to the trial, there is an aspect of it that has been abused again, even though they apply it both in the High Court and all the courts. That is trial of defendants in absentia, when there's a direct criminal complaint. If you look at part 36 very well, section 352 says, where a case is called in which a summons has been issued and the defendant does not appear or pleads guilty under the provision of the 135 of this act, and no sufficient cause is offered for his absence, then the court where it is, where the court is satisfied that the summons, if any, has been duly served, may issue a warrant called bench warrant for his arrest. Then sub 4 says, where the court in excess of his discretion has granted bail to the defendant, and the defendant in disregard for the court orders fails to surrender to the court, to the order of the court, or fails to attend court without reasonable explanation, the court shall continue the trial in absence and convict him unless the cause is reason or otherwise, provided that proceedings in absence of the defendant shall take place after 2 adjournments as the court may deem fit. In this case, please, I submitted my paper. I don't know why it's not showing there. That's what I will follow up. So, but what he's trying to say is that this section applies when a summons is issued. And the summons is only issued when you commence proceeding by direct complaint. When a summons is issued, that is, and the defendant fails to appear after granting bail, the court can now proceed to try him in absentia. In this case, it is very, very clear by section or part 36. Part 36 is talking about direct criminal complaints. And when a bail is granted and the defendant fails to appear, it can proceed to try him in absentia. And the provision is so clear, only that from the arrangement of ACJA is not properly arranged like a CPC and other status. It is being mixed up in such a way that at times we find it very difficult to know the section applied for particular procedure. But in this case, when people are arraigned or a defender is arraigned based on a FIR or a charge, and the bail is granted and he fails to appear, the court will proceed to try him in absentia. I know this is a very difficult thing to understand, but when we finish, please, we'll take our ACJ and see it very clearly. This trial in absentia applies when summons is issued, as stated by the ACJ from section 352, sub 1, 2, 3, 4, 5. It is very clear there. So in this case, it is only applicable when a summons is issued and not when a case comes by way of a charge or FIR. ACJ also makes provision for trial when the defendant could be excused from appearing in court, and that is under section 266. Under section 266, it said that the defendant shall, subject to the provision of 136, be present in court during the whole trial, unless 1, he misconducts himself in such a manner as to render his continuing presence impracticable or undesirable. Number 2, at the hearing of interlocutory application. So when the charge is filed or FIR is charged, either in the High Court or the Magistrate Court, this is the area, the only condition under which the appearance of the defendant, his appearance in court could be excused. But in a trial in absentia, it is only when a direct criminal complaint is filed. Then, also in the lower courts, there is something we called the recall of prosecution witnesses for further cross-examination. In the lower court, the cases are usually filed by the FIR most of the time, even though now we file charge and a complaint. But when it's an FIR and the FIR is brought before the court, the moment the defendant denies the allegation in FIR, there's no offense in standing trial. The next procedure is the prosecution to continue to produce evidence, to adduce evidence, at least to show that to ensure that evidence discloses any offense against the defendant. And after producing the evidence, the court will sit back and look at the evidence and know whether the evidence discloses any offense. It might be the one that is not even in FIR, any offense at all. And if there is, he will now draft a charge. And that's when the defendant knows the offense that he's standing trial. Now, after that, before the defense counsel starts giving evidence, he has the right and his duty to demand that the prosecution recall or some of the prosecution witnesses for further cross-examination. Because at the time the prosecution was producing witnesses and it was cross-examining, it might be a different offense from the one that's been drafted. Because the court is not bound to draft a charge with respect to the one that it was an FIR, which he took plea. So in this case, it's the duty of the defense counsel to ensure that he recalls and cross-examine properly. Then another issue is on issue of plea bargain and compounding of offenses. There's area where the provisions in the CPC where you can compound offense. ACJ did not provide for compounding offenses, only provide for plea bargain. But the difference is that in a plea bargain, after the prosecution is involved, and thereafter, when the court accepts it, there must still be a conviction, even though with a lesser offense. But in compounding offenses, the parties can settle out of the court, and after settlement out of the court, and once it's brought to the notice of the court, or the terms of settlement is brought, the court will acquit the defendants. So a clever defense counsel will prefer to go by compounding offenses than going to plea bargain where the defendant will still remain a convict. But that of compounding offense is limited to certain offenses. Not all the offenses. So offenses like criminal trespass, offenses like mischief, offenses like criminal intimidation, grievous hurt, criminal breach of contract of service, and all these things. When you have those offenses and you know that the nominal complainant or the complainant intends to settle with the defendant, you can go by compounding offense. You can apply as a defense counsel to settle the matter out of the court so that he will be acquitted instead of convicting him. So it's the duty of the defense counsel to do so. Then another one is the issue of forfeiture of bond. On forfeiture of bond, when the defendants, after granting bail and he absconds, usually the surety is being called to show cause why he should not forfeit the bond. And most of the time, our courts, once they hear that the defendant has absconded, they will just invite the surety and send him to prison direct. Please, it is very, very wrong. A defense counsel should not allow that to happen to his client because there's a procedure for forfeiture of bond. The court's supposed to call the surety and ask him to show court why he should not forfeit the bond and listen to him carefully. If eventually he shows that he did not connive and did not has been diligent in ensuring that the defendant comes to court, in this case, the court can reduce the bail condition. There's something called remission. Remission means that even the court says, I didn't bail in sum of 10 million, the court at the forfeiture of the bond can, after listening to the surety, can reduce it even for 1 million or 2 million. It's not a must that a court must forfeit, the defendant must forfeit, or the surety must forfeit the total amount. And it's the duty of the defense counsel to ensure that I always plead for remission, because it's always deliberate when the court asks the defendant or surety to pay a very high sum amount. The essence is to discourage the surety from, or the defendant from running, knowing what the surety will suffer. But that does not mean at the end of the day that you pay the full amount. But it's during the process of forfeiture that the court will listen to the surety to explain, to know whether he's involved or participated or aided in any way for the disappearance of the defendant. So it's the duty of the defense counsel to do so. Again, when you have a client and is arrested by the police, most of the time, when the the police grants administrative bail and the defendant runs away, or the suspect, sorry, at this stage, so most of the time, when the suspect runs away, the police will call the shorty, and arraign him for screen an offender. Please, such is not a screen offender. Ensure that what should be done is for the police to take that shorty to the court, magistrate court, and start the process of forfeiture of the bond that is entered at the police station, not to start arraigning the defendant for screen an offender, which at the end of the day they will not succeed. Then I come to the issue of arraignment and plea of the defendant. So the defense counsel still need to have a role to play there. The defendant to be tried on an informational charge shall be arraigned in accordance with the provision of the Act relating to the taking of pleas and procedure on it. Objection shall not be taken. So ACJA section 396 says that objection shall not be taken or entertained during proceeding or trial on the ground of an imperfect erroneous charge. That's section 221, sorry. Then, another section 2396 says, after the plea has been taken, the defendant may raise any objection to the validity of the charge or the information at any time before judgment, provided that such objection shall only be considered along with the substantive issues and a ruling thereon made at the time of a delivery of judgment. So in this case, the ACJ does not encourage the objection of erroneous charge at that stage, and even if it's objected, the ruling should be taken along with the substantive offense. But the question is where, the law is that before the defendant is being convicted, when he pleads guilty, he must have admitted to all the ingredients of the offense. In a situation where the charge is read and the defendant pleads guilty, and when he's pleading guilty to erroneous charge that had not even the ingredients of the offense, and the law says you must admit all the ingredients before he is being convicted. So in this case, the object of the ACJ is that at that stage you should not even object. But in this case, having pleaded guilty, there will be no trial. The issue of taking it alongside the sustainable matter will not arise. Then this duty now falls on the defense counsel to ensure that the defendant is not convicted based on an erroneous charge, a charge of which he did not understand or does not even carry the ingredient of offense. And my view is that at that stage, the defense counsel must make sure that he raises the objection timelessly before he's being convicted, because after pleading guilty, the next is to go for conviction. So the defendant should always be awake and sure that he does the proper thing. Then the case of Nweke that was cited, Nweke State, that was cited by the lead presenter, yes, where the defense counsel asked for the materials to make sure that he has a proper defense, and it was refused. The Supreme Court was able to do the needful. I think that has been taken care of by Section 350 of ACJA, that says that the prosecution should always ensure that it makes available to the defense or defense counsel all the materials it tends to rely in the prosecution of the case. I think that actually has settled it, because we know before then, those case of Nweke and even the case of the Section 122 of the CPC, they did not allow the issue of, did not allow Section 122 of the CPC. It clearly says that the defense counsel or the defendant should not be allowed to be given case, have access to case diary or material needed for investigation or prosecution. So, but this provision of ACJ has cleared that, and very, very simple. Then we come to the issue of
My Lord, yes? You have 30 seconds more, please.
30 seconds?
Yes, sir.
Okay. Okay, so at this stage, I think it's better for me to even to stop at this stage because with what I've written, I think they can go through it and make up the rest. Thank you very much.
Thank you very much, my lord. I think we have been richly blessed by my lord's contribution. It started from the assumption that some of us used to believe that the CPC has been repealed in FCT, and from there the Lord went to how direct complaints can be brought, and also the difference between FIR and the direct criminal charge. My Lord also educated us and also enlightened us on the issue of trial in absentia, and how the procedure for that. How do we recall? My Lord also told us how we could recall prosecution witnesses and when to seek for those recalled. Then one of the most beautiful part of it for me is the choice to be made between plea bargaining and compounding offenses, because if some category of offenses can be compounded, why do you have to go for plea bargaining? And also on the forfeiture of bond, the procedure and the opportunities for the mission, instead of the strict view that when failure of the accused person to show up, it means that there will be forfeiture of bond, and the surety will not be taken up for some other things. Then arrangement and pay of an accused person, procedure for listening objection, because actually what the ACJs has provided us the opportunity as defense counsel not to, if you raise the objection at the old ways that it's been done, you will not get the full benefit of the ACJA. So I thank the Lord for opening our eyes to that. I want to use the opportunity to welcome into our midst one of the contributors, Anole Usman Esquire. Please, the MC, I want you to come and introduce him formally so that we can.
Thank you very much, Mr. Chairman. We would like to welcome the presence of Mr. Anone Usman Esquire. Barrister is from the firm of Ahmed Raji & Co. His professional background is thus. He's a passionate and motivated legal practitioner making strides in corporate and commercial law, known for his strong work ethics, attention to detail, and commitment to justice. He has quickly established a reputation as a promising young professional in the legal community. He also has strong interest in maritime and admiralty. He has great interest in transactions and cases that impact directly on the nation, and this is responsible for his constant involvement in major cases of national importance. Thank you very much. Welcome, Mr. Anone Usman. Over to you, sir.
Another round of applause for him. Now that I've dealt with areas where I cannot, my orders may not stand, I think now we're getting to areas where I can have strict enforcement and my orders will stand. Please, we will limit contribution to 10 minutes now, and let it be swift and direct to the point. My Lord has taken us around the whole of ACJ and also CPC. If your intervention relates to areas that have been effectively covered by my Lord, you can leave them out. Just say, I concur with my Lord. And let us on this issue. So let us move on swiftly. Now I want to call for his contribution, Osage Isarame Esquire. Just give him another applause.
Chairman, my lords, and learned senior advocates present, and learned senior colleagues and colleagues. My intervention basically is going to be on the issue of tendering extrajudicial statements under cross-examination by the defense. My intervention basically is a bit away from the norm, and the norm which the lead speaker said is when the defense wants to tender its extrajudicial statement under cross-examination, he must point, or the counsel must point to the witness the area of contradiction sought to be made. And it's only after this had been done that the statements can be tendered and admitted in evidence. I feel this is a bit technical, and also would really not lead to fair hearing or fair trial as expected by the Constitution. Particularly if you look at Section 36 of the Constitution, which basically says the defense should be availed all materials. So if, for instance, the defense knows a material exists, which is an extrajudicial statement, and it points it out, I think at that point, for us to have a fair trial, I think the document, most of the time, which is coming from the prosecution, should be allowed to be admitted in evidence without necessarily laying extra burden on the defense by saying, point out the contradiction to the witness before this document comes in. I feel is extra burden, which basically also goes contrary to our judicial system of a defendant should not prove his guilt, should not prove his innocence. So I feel like, particularly looking at the case of the Supreme Court in the recent decision in Okoli and the states, basically the Supreme Court found the norm, which says point out the contradiction and the rest. So if this is done, from my own experience, basically I'm looking at the trial, most of the times judges admit statements tendered by the prosecution, no matter how tough or maybe how serious the objection is by the defense. So why now put extra burden on the defendant when all he just wants to do is to bring a document in, which probably will aid the judex to see the reality of things. You know, the normal saying that it's better to allow a 9 guilty person go free than to convict an innocent man. So, and our system also in prosecution says, look, put all the cards on the table. So once a statement is mentioned and it comes to the point, it comes to the knowledge of the judex that, look, this document actually exists, but the prosecution failed or had refused to bring it before the court. I think it should play a mind, it should do something to the mind of the judex that, look, it seems there's something the prosecution is trying to hide. And for this reason alone, I believe the document should be allowed to go in, just for the sake of having a fair trial, which the lead speaker said. The essence of the criminal prosecution basically is to have a fair trial. And also, another point that is also very important is the ethical issue when the prosecution fails to bring a particular document in or present a document. I think it's very, it's unethical for a prosecutor not to put all materials before the court. Basically, it's trying to convict at all costs when you know a particular material might aid the discharge or acquittal of a defendant. So my point basically is very direct and very short. I don't think I won't want to eat much into the time of everyone. So if perhaps maybe questions are asked, I can shed more light on it. But this is my short and direct intervention.
Thank you very much, my brother, Mr. Osage. Now, he modestly said that his contribution is short, but I want to tell you that they are not just short, they are very weighty. Because the way you look at the weight of that intervention and contribution, you will see that they are picking our brains into issues that we overlook most of the time. When you spoke about the applicability of Section 36, when you're talking about Section 36 and the burden you're not placing on the defense, that before, if I know that there is a statement that has been made and it's been suppressed, and you want me to come and first of all highlight and the rest of it, it may be putting an additional burden on the defense. And if the objective is fair trial, I mean, the fact that I can bring it to the judge and say, there is something that this man is hiding, let him bring it out. I think that should be enough. He said that, and I think it's a very good point. Then on the ethical issues, you see, prosecution or defense, like the lead speaker said, has an objective, that is fair trial. If the objective is fair trial, why are you suppressing evidence that you know will aid either the prosecution or the defense? So let's give Mr. Osage another applause. These are very serious issues that we need to put at the back of our mind when we are engaged in other role. Thank you very much. So I'll now call on my brother Anone Usman Esquire for his contribution. You have 10 minutes. Please make it direct, direct kill punches like Mr. Osage. Thank you very much.
Thank you, everybody, and good afternoon, my lords and everyone present here today. For us, we have intervened strictly as counsel who has undertaken defense of defendants, or as they used to say, accused persons in court. And we, in doing so, we are mindful of the fact that ordinarily the burden of proving the guilt of an accused person or a defendant is with the prosecution. So it would appear, given that the role of a defense counsel is limited, but therein lies the pitfall, because you feel like there's very little for you to do. After all, they have the responsibility, then you will be relaxed. But our charge here today is that we must be diligent, and as much as there is a role, there's a duty on the prosecution to prove the guilt of the accused person, our primary role as defense counsel, regardless of what the person is accused of, is to make that duty on the prosecution even more cumbersome. So we're not, as defense counsel, expected to make it easy for the prosecution to send our person to prison or a fine, depending on what the punishment for the offense that is alleged against them is all about. So to this end, what we have done is that deriving from all the cases that we have been given to look at, we have identified several areas where defense counsel did not do what they should have done in making the work of the prosecution very difficult. And it's those areas that we want to call attention to this afternoon, so that at this stage of proceeding, the defense counsel should show more diligence, more vigilance in ensuring that nothing is given to the plaintiff, and the prosecutor. And I don't want to sound as if I do not like the job of a prosecutor, but I've been called upon to advise on the role of a defense counsel. So I will start first of all with the issue of confessional statement. We all know that a confessional statement is good enough to convict an accused person or a defendant. So that's the first point where a defense counsel has to show his capacity. For a confessional statement to be admitted, you must do all that you need to do if the law allows you to take out that statement, because that on its own can send the person to prison. So as a diligent defense counsel, confessional statements, you have the responsibility to ensure that these statements do not go in, because on their own, they are enough to convict the accused person. So if there is a room for you to make sure, and I'm not talking about unethical practices here, if a confessional statement is one that was not obtained as the law requires you to take them from the defendant or the suspect at that point, you must, as a defense counsel, be diligent enough to prevent that document from going in. Otherwise, your client, the defendant, will face the full wrath of it. The next part we want to address is the issue of witness statements. In this point, we're dealing with a situation where contradiction exists between witness oral testimonies and his written statement concerning which the opposing party intends to rely on. At this point in time, again, you are called upon to be very, very vigilant, to be able to show that, oh, there is a contradiction, and also for this reason, that it should not be accepted to prove the guilt of your client. And then we've also looked at admissibility of evidence to ensure that the only documents or the only evidence that comes into for the court use are documents that are legally receivable by the court. Because as we say, or as every document, every piece of evidence that is adduced is intended to prove the guilt of your client. And if you want to ensure success for your client, you must be diligent to say that documents should only be allowed to enter into the evidence where in fact it's been demonstrated to be legally receivable documents. And then the duty of a counsel to a defense counsel doesn't stop with just regular trial. That duty extends to even where he has lost the case at the trial court and he believes that there are grounds for appeal. At that point in time too, as a counsel, as a defense counsel who wants to secure the release of your client on appeal, you're also to focus on good and quality grounds of appeal against the judgment of the court to ensure that the client ultimately is the judgment of the court convicting him for the crime he's alleged against is overturned. So these are the areas where in criminal trial process from the High Court to the Court of Appeal or to the appeal stages where we believe that the intervention of the defense counsel can play a very key role. We are mandated to, at each point in time where prejudicial steps legally allowed prejudicial steps are taken against, can be taken against your client, you're allowed to step up and do what you are called there to do, which is to prevent everything that could harm your client's interest and to ensure that ultimately you achieve success. So as we have said at the beginning stage, your duty is not to make very easy the burden of proof imposed on the prosecution. So you are at every point in time encouraged to be diligent enough to make that role very cumbersome for the prosecution. So I thank everybody for the attention.
Thank you very much, Mr. Anolan. The summary of what he has told us is that we need to be very, very diligent so that we'll be sure that justice, which is the aim, is served. He pointed to us about confessional statement that we should try our best to make sure that, and the reason why he gave was very good because I had the opportunity of to read his contribution. I'm sorry that I had to limit it to 10 minutes because the point he was trying to make was that as defense counsel, we were not there when those confessional statements were made, and we need to be wary of them when they are coming in. So when they're not there, you just don't have to allow to take off the burden. The burden to prove the case beyond reasonable doubt is on the prosecution. And if you are really interested in justice being done to your client, don't be the one that will go and be lifting burden from the person that legally are supposed to bear the burden. Let them do their work. That's what he's saying in the nutshell. Then also he talk about witness statement and evidence, witness statement and slash evidence. And we should also be vigilant to look at the differences vis-a-vis the witness statement and the evidence being given in court, because those are areas where you really need to do to be very vigilant in cross-examination. When there are contradictions, make sure you point them out, and because the essence of cross-examination is to discredit, so that you can discredit the witness. See, we still have to dot this back to fair trial, because if you don't do that, the accused person may end up going to jail for an offense he didn't commit. So you need to be vigilant enough to know that when there are contradictions between the evidence given by prosecuting witnesses and their statement made earlier, you put them out, cross-examine them on it to make sure that at the end of the day, justice is served. He also told us that to have a clear mind when he's talking the issue of admissibility of documents are coming in, and so that we will be focused and make sure that documents that are relevant or that have not met the standards required of for admissibility, we don't allow them to slide into the records. And also, while you are doing the case, you also are also preparing your mind that in the event that the matters do not go into your own way, in areas where you think that justice has not been served, because we should also bear that in mind. You don't have a responsibility to go and be plugging the docket of the court with all kinds of frivolous appeals. Areas where you know that the ruling or judgment are not in consonance with rule of law, with the fair trial requirements, with admissibility requirements, you note them down. You don't have to start fighting the judge in court. There is opportunity for appeal. You take them to appeal. So thank you very much, and please give me a round of applause. Now we have come to the question and answer session. Please, any question for any of for the lead speaker, the panelists, we take all the questions, and when you're asking a question, direct to the person, so that the person that we after the question we know who are answering questions. And this session is going to be limited to 7 minutes. We should do that in 7 minutes, because I think the time for lunch is here. And when I want to leave my office, he asked me what I'm going to do there. I said, 1, I'm going to participate in the session, and 2, I'm going to eat lunch. So I don't want any of the two to conflict. So thank you very much.
Thank you very much, sir. Pending when we make up our minds here.
Okay, thank you very much. I don't know if you can hear me. Okay, thank you very much. Yes, on this particular subject of discussion, I think the need for defense counsel to be diligent and to avoid set common pitfall in conducting defense on behalf of a defendant in criminal trial cannot be overemphasized. Why I'm saying this is because someone's life is at stake. So a certain error or a common error could result to conviction of a defendant standing criminal trial, which could be, some of these errors could be very, very fundamental, if I may say. And one of these errors that I've noticed over time, which I personally have witnessed in court, is a defense counsel not being able to understand the distinction now, the distinction between retraction of confessional statement or raising voluntariness to a confessional statement. This is a very common error that I have seen or I've witnessed in court from a defense counsel. You see a defense counsel raising objection to a confessional statement, and you see the mixed up of either a retraction or the fact that the statement was taken involuntarily or was rendered involuntarily. And this could be very, very fatal to the case of the defendant, if I may say. In the case of Abubakar against the state, the Court of Appeal has this to say. The law is that a retraction of a confessional statement is not the same thing as denial of the voluntariness of it. And the Court of Appeal in this judgment, this decision, made reference to the Supreme Court case of Joseph Adekunle Sale against the state. It's a 2020 decision where the Supreme Court held as follows. But an objection to a confessional statement
Hello, please
on the ground of...
Please be direct. Go direct to the question, please. The question that you want to ask.
A contribution, not a question. That's what I said, sir. Let me say. Okay. So in this decision by the Supreme Court, they made a clear distinction between retraction of confessional statement of a defendant or raising voluntariness to the statement. And I've seen many scenarios where a defense counsel, mix these two up, and they are totally not the same. And I think we need to take note of it so that we could raise the proper objection to admissibility of a confessional statement. That is my humble contribution. Thank you very much. Is a question? Ma, please.
Good afternoon, everyone. All protocols duly observed. I hope you can hear me.
Yes, we can hear you.
I hope you can hear me.
Yes, we can hear you.
Very much. Quickly, I'm going to ask these questions. Okay, sorry, my name is Iye Idama, the DPP, Kogi State. Quickly, I'll just ask these questions. Some time ago, I know I came across an authority that said it should be the defendant who should be able to inform the court whether his statement was voluntary or not, and not the counsel answering it for the defendant. Most often you see that the counsel will want to say, oh, my client was tortured, oh, he didn't make that statement. But I came across an authority some time ago that it should actually be the defendant that says so in the open court. So I want to have clarification on that it shouldn't really be the counsel, but actually the defendant in question. Secondly, what is the role of legal advice in matters of direct complaint fire? Number 3, when should the defense counsel advise his client to plead guilty? Thank you.
Thank you very much for that question. We have one more here from the audience.
There's still a question.
Good evening, sir. My name is Abdul Malik. So my direction is directed to the lead counsel, the lead presenter. With respect to the case of Okemini and COP, where the conclusion of the Supreme Court was that the trial or the charge should be remitted back to the trial court to be assigned to another judge. And the lead presenter opined that the Supreme Court should have quashed the charges. So my own question is this. The subject of appeal before the Supreme Court was the motion of the defendant, the appellant at the Supreme Court, to compel the prosecution to give them or to supply them with adequate facilities and material to prepare their defense. So that was the application before the trial court, which was refused by the trial court and also the Court of Appeal, and same constituted the subject of appeal at the Supreme Court. So being that the charge itself wasn't a subject of appeal at the Supreme Court, was it possible for the Supreme Court to make any ruling on the charge or as to quash it when the validity or otherwise of that charge was not the subject matter of appeal before the Supreme Court. If there is any way out of that, I would like to know.
Before you, the other question, I would just, so that you won't waste time on it. After when he was presenting the paper, he said, he told you the position of the law, and he now said his own opinion, what he feels. There is no way his opinion will affect the position of the Supreme Court. And clearly, as you have said, what was before the court, and what he's saying that, considering, he gave you the reason why he said, considering the time and effort that have been put in, that why do they need them back for another lengthy trial than end up in Supreme Court? So it's not that what you are saying is that what you are saying is not correct. In fact, the way you have expressed it, the Supreme Court would have found it difficult to have done otherwise. So let us not overstretch that. I think there is a question that is supposed to come from last house. Let's make the last one because it's almost 3:30, so that you can.
Mr. Abdulhakim-Audu, could you please? It's like we have a connection problem.
Good afternoon, everyone. My name is B.M. Musa Esquire. Okay. Can you hear me now?
We can hear you.
Can you hear me, please? All right. Okay, my question goes thus, and I think particularly Mr. Gay. Can the Attorney General or a lawyer from his chambers take over a matter that was a case that was fed by way of a direct criminal complaint? If this is answered in the affirmative, do you need a fiat of the AG to prosecute a direct criminal complaint? That's my question. Thank you.
Thank you very much for all the questions. Now I'll call on my brother Adidayo GSCM to respond to the questions directed to him.
Thank you very much for your thoughts and the questions put forward to me. I'll start with the question raised by Mr. Abdullahi Yahya on the decision of the Court of Appeal in Dankara versus FRN. What happened in Dankara versus FRN was that at trial, the investigating police officer tendered in evidence the extrajudicial statement obtained from some of the witnesses. He tendered it in evidence. And when he tendered it in evidence, an objection was not raised by the defense as to the admissibility of those documents. And when we got to the Court of Appeal, I didn't do the matter at the trial court. I handled the matter at the Court of Appeal. Part of the objections we raised at the Court of Appeal was that extrajudicial statement ought not to have been tendered through the IPO, and that the purpose of rendering an extrajudicial statement is for the purpose of contradicting the witness, right? Because if you read that decision, you realize that it was on the basis of those extrajudicial statements, in addition to some other evidence on the record, that the court used to convict the appellant and sentenced him to life imprisonment. But the Court of Appeal agreed with us and said that no, the trial court was wrong to have admitted those statements, and not just admitting them, relying on them for the purpose of convicting the appellant. So that's the position in Dankara versus FIR. So I think the position of the law still stands, that yes, once you want to tender an extrajudicial statement, the only time, irrespective whether it is a confessional statement that you are challenging on the ground of involuntariness or retraction, which has to go to the author of the document, that it has to be tendered, it has to be raised at the time of objecting to the statement. Now, on the issue of prosecutorial conduct, misconduct, if found that the prosecution is withholding evidence, yes, I agree with you, sir. I agree with you, sir. Because experience has shown that, I'm not saying all prosecutors now, but experience has shown that we see instances where they deliberately withhold some of those facilities, some of those documents that will actually help the defense in proving or defending the charge. So why not? If there is evidence that the prosecution deliberately withheld such an evidence, I think apart from laying a complaint to his employers, right, that it's also a professional misconduct that can be pursued with the LPDC. On Chinelo's question on the issue of deferment of objections to the charge. Yes, that's the case of FRN Ibrahim Shehu Shema and FRN. It's a Court of Appeal decision. Coincidentally, my Lord Justice Oredola delivered the lead judgment in that case. And what the Court of Appeal held in that case was in respect of Section 2213962 of ACJA, and said that it is not all category of objections that can be deferred to the end of trial. If it is an objection that challenges the jurisdiction of the court, particularly that has to do with abuse of the court process, that the court has the powers to determine that before proceeding with the charge on the merit. So I think that position is still extant. To the best of my knowledge, I don't think it has been set aside by the Supreme Court or even appealed against. The motion was, there's a question on when should a defense counsel advise his client to plead guilty? Yes, well, my answer is simple. Based on, if you don't have a defense, your client should plead guilty immediately. It's not, I don't think there's any rocket science about that. It's a matter of you can also enter a plea bargain depending on the fact and circumstances of the case at hand. And on the case of Okemini and versus COP, I think the chairman has answered you on that. But my view, as I said, was that I felt strongly, yes, I agree that the position before the case made by the appellant before the Supreme Court is as regards the issue of facilities for the prosecution to make available to the defense facilities to defend himself. But I'm also aware that the Supreme Court has inherent powers to make another, if it's so apparent, like in this case, that there was a breach of the appellant's fair hearing. And as I said, this is an appeal that started all the way from the magistrate court up to the Supreme Court. You know, what is the whole essence of criminal trial? It's as held by the Supreme Court, another court of superior record. You know, it's not a matter of persecution. It's a prosecution. Or you keep somebody right from the magistrate court up to the Supreme Court, deny him facilities, and now you now tell him to go back again to go and start trial all over again. Well, I think to me, which is a view I hold strongly, that if I was to defend the appellant in that type of case, that is the position I would be making to the Supreme Court. I think that answers my question. Thank you very much.
Thank you very much. Now I go to my Lord, Honorable Justice Odo, for response to the question directed at him. My Lord.
Okay, thank you very much. For the last question asked, whether AG can take over a case commenced by direct criminal complaint. Please, AG has unfettered power to take over any criminal matter. Direct criminal complaint is a criminal matter filed by an individual, a private person, or his legal representative. So once it's filed, AG has power to take over. Osahona and Federal Record of Nigeria is very clear. Whatever criminal matter, AG has over rights to take it over. Then, on the issue, a fiat will be given for the prosecution of complaints. Please, the ACJ made it very clear that the direct criminal complaint is filed by a private person, that's an individual, or his legal representative. and can so prosecute the matter. So in this case, the state is not involved. The prosecutor there is called private prosecutor. The section 494 of the CJ defines private prosecutor to include a person. So he said a private prosecutor does not include a person prosecuting on behalf of a state or public officer prosecuting in his official capacity. So in this case, direct criminal complaint is meant for an individual to be filed, the case is to be filed by an individual or his legal representative as provided by section 89 of the ACJA. That is the answer as to that one. Then the other one, the first person that talks about retraction of a confessional statement and the issue of voluntariness, I think that one is very clear. That when you talk about retraction, because the defense counsel can only oppose admissibility of a confessional statement in two ways. Either that the defender did not make it, or that he made it but was forced to do so. When he says he does not make it, he arises in so many ways. When he says that it's not my handwriting, I did not make it, there's no literate jurat, it is mutilated, it was not confirmed by the senior police officer, and all this mean that he's retired. He's saying he did not make it, and law is that it's admissible. The rest goes to the ways to be attached to it. But when he said, I made it, but I was forced, coerced, or promised to do so, that's when the issue of voluntariness comes in, and trial within trial will be conducted. So in this case, with the case of this Najofo and the state now under section 17, what I ask now is when the prosecution witness is giving evidence and wants to tender confessional statements, and the defense counsel says, or the defense counsel or the defendant says, this was not is not comply with section 17, or because when it was made, a lawyer was not there, or a person of my own choice was not there. What would the court do? Would the court, because it was objected to admit it, without hearing the prosecution to prove it, beyond reasonable doubt, to at least hear both parties? I think I earlier said it. So the question now is it going to lead to another trial within trial? Because the court cannot merely admit it simply because the defense said section 17 was not complied. You must hear the other party. And to hear means you are going on with another trial within trial. So thank you very much.
Thank you very much, the lead speaker, all the discussants. I want to say that the truth is that we don't really, the way we have enjoyed this session, we don't want it to end, but we just have to put an end to it. We have learned a lot, and I know that the benefits of this Rule of Law Summit will not be lost on us. I want to thank the originator and the brain behind the Rule of Law Summit, JBWSCM, and I want to commend also all our seniors to think in this line and start things that will raise serious discourse like we are having here. I want to pray that God will enrich him more and also grant him long life and prosperity so that we can benefit more from this summit. Thank you very much for this session, and I want to first let's give everybody the round of applause, and particularly our friends that are joining us from the Glass House and all the people that are online. I'm aware that from all over the world, people are online joining and watching this live. Please, let's give all of them a round of applause, please. Thank you very much, the organizers. This brings to an end the second session today. Thank you.
Thank you very much, Mr. Chairman. Will we rise for the national anthem?
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland.
invite our distinguished guests to have their lunch.
Thank you very much, my lords. We are most grateful.
Please, let's have a group photograph with all the panelists
Please,
and
first
all
of
our
all,
distinguished guests just here
our lunch can
with the
be served.
chairman.